Hey there, Aaron Millar here. I'm making this video, and you likely received it, with an email setting up a meeting with one of our team, your attorney, to go through your preparation for your deposition. Now, what is a deposition? A deposition is where you meet in a conference room, something like this, with a court reporter taking down everything you say, opposing counsel who asks you questions, you answer the questions, then the court reporter writes it down. I or your attorney who's working with you in this case on the day-to-day legal needs will be sitting next to you and not guiding you, but listening very closely along with you. But it is a chance for the other side to learn your understanding, your view of the facts of your case. It then helps them, the opposing attorney and party, understand whether they have a strong case or a weak case, or how that case looks like as you proceed, and knowing how to structure a settlement offer to try to resolve the disputes that are at issue. For example, if they feel like you are a witness who tells the truth and comes across as very credible in your testimony, then they might be more likely to try to settle this case because they don't want to go to trial and have you on the stand being as credible and as clear and as intelligent as you are. Or if they say, oh, you know what? This person doesn't know the facts very well, or mixes up the facts and changes the story, then they might be more emboldened to proceed to trial and not resolve the case beforehand because they feel like you are not as good of a witness. That, of course, all implies that you are a party to this dispute. In some cases, our clients are third parties, which changes that dynamic a little bit because you have nothing to settle. But in most cases, you are a witness because you are a party to the case. This deposition will only be used at trial if you say something that's different than what you said at the deposition and they don't like it at trial. So they want to show you, hey, isn't this what you said at your deposition, to try to impeach your testimony, to impeach your credibility as a witness, to make the rest of your testimony look less credible. So here are some key tips to remember as you approach this deposition. We'll go over this during our deposition preparation meeting. We, as in your attorney and you, will walk through these steps. So listen to the questions very closely. Listen attentively, understanding exactly what is asked. If you don't understand, you can indicate, I don't understand what you're asking. For example, if they say, did you work at this company? You can say, when? I don't know what time you're referring to. And then they can answer that question or ask the question in a more clear way. Did you work for this company in the year, 5 years ago or whatever? You want to be truthful in all of your responses. You might feel this like, oh, I don't want to say yes when I know the answer truly is yes. However, I will tell you, you need to be entirely truthful. Now, that doesn't mean you need to share all of the facts or all of the details unless they ask. In fact, I want you to be truthful, but also brief. There's no need to go in and share every single detail unless they ask for literally every single detail. So you listen to the question, you answer it truthfully, briefly, and then you stop talking. There will be times for you to work in the themes of your case. And we'll talk during our meeting about what those themes are for your deposition or in your case so that you can work those themes in to your answers. Before you answer any question, though, you'll want to wait for your attorney to interject with an objection if it's appropriate. Then the attorneys put those objections on the record, and almost always you'll then have the opportunity to answer the question. You will occasionally be directed by your attorney not to answer the question. And if that happens, of course, you don't answer the question. There will be breaks throughout the day, but please plan on a day that will be, if you are a party to the case, up to 7 hours of questioning, but that doesn't include breaks. So it can last all day. So you'll want to be prepared for that, build in the flexibility that you need to achieve that, and be prepared kind of physically and emotionally. Think about what helps you to be in the best headspace as you prepare for that. Like I mentioned, this video likely comes with an email that describes or sets up a session where your attorney and you will walk through and practice answering questions that could get asked. So there may be something that is, you think to yourself, this would be a difficult question for me to answer, but I know it's relevant and I think they're going to ask it. Those are the ones you want to be sure to practice. That practice session should not be comfortable. It should be a little uncomfortable so that when the day comes for your deposition that you are comfortable. And we will help you through this process. We have helped hundreds of clients through these depositions, and we are grateful to be able to guide you through this step of the process.